I should unmute myself before I talk. So good afternoon, everybody, and welcome to our April in the Boardroom with attorney Andy Phillips in Attolles Law, where we are going to talk about the FMLA and ADA and managing leaves of absences. For those of you that are looking at your screen right now, you may notice that we are missing the person whose name is in the title of our In the Boardroom webinar series, and that is Andy Phillips. Andy is not going to be joining us for today, and that is totally fine. And everyone can tell Andy I said so. We need a break from Andy, don't we? Sarah and Dan aren't going to say anything, are they? They're gonna be nice to Andy and the boss. Andy, I was on the phone with him earlier today. He said I could make fun of him a little bit, so that's all okay. So actually we have Dan Unerdal, is that? I'm gonna butcher your name, and Sarah Hanneman, both from Attolles Law, joining us today. Both Sarah and Dan have worked with counties on a variety of issues, and they both have a wealth of legal and practical knowledge regarding employment law matters impacting counties. And he also said I'm supposed to say that they are far more entertaining than he is. And then I can make up whatever other stuff I want to make up as well. So, that being said, I don't want to take up a lot of time. I know Sarah and Dan have prepared a wonderful presentation. I believe, Sarah, I heard you speak in Monroe County a few months ago, and it was a wonderful presentation. So, even though Andy is not here, I have 100% confidence that Dan and Sarah are going to amaze us and do an even better job than what Andy Phillips would today on this particular topic. So, just a couple of real quick housekeeping items for everybody. This webinar is being recorded, and the recording, along with the PowerPoint presentation, will be posted on the WCA webinar for you to access at a later date. And if you have questions or comments throughout this presentation, we will be monitoring both the Q&A as well as the chat feature on Zoom, which for most of you is probably on the bottom of your screen. It says chat, just click on that, type in your question. In order to access the Q&A screen, I think they made some changes within Zoom, and now you have to click on more to access the Q&A box. So with that, I am going to turn it over to Dan and to Sarah now, who are going to talk to us about this very important employment issue.
All right. Thanks, Sarah. We appreciate that introduction. I think I speak for both Dan and myself when I say that unfortunately, neither of us are quite as entertaining as Andy Phillips. But that said, we do certainly have a wealth of knowledge between us on FMLA and ADA. Dan and I deal with a lot of employment issues for public sector employers throughout our days here at Attolles. So we've put together this presentation. We know FMLA and ADA perhaps are not the most glamorous or most exciting topics that you could spend your lunch hour reviewing. But it is one of the more practical topics because we know you guys are dealing with this with all of your employees day in and day out. So it's a really good idea to always review your practices and your knowledge when it comes to FMLA and ADA. And the area Dan and I see a lot of questions arise is also, does FMLA ever turn into ADA, and how do these two laws intersect or kind of play with each other? So we're going to hopefully give you some nuggets to take away and take back to your counties with you. And with that, I'm going to turn things over to Dan to start us off.
Just a couple of initial matters here. Disclaimer and tips, Sarah and I called it. The FMLA and the ADA are exceptionally fact specific and dependent on individual facts and circumstances in any given situation, as you all know. First time through any FMLA or ADA matter, the first question is, what are the facts at issue? So as always, please consult with your legal counsel when these situations arise. And we're going to try to be really practical here. The first most practical tip we can offer is determine which laws apply the law consistently, and document. First off, some basics for you here, okay? The federal and state Family and Medical Leave Acts are a set of laws that allow qualified employees to take a specific amount of leave with job protection for certain circumstances. So, in the broad strokes, issue allowable leave. Remember that the Wisconsin and federal FMLA laws are different. So, you have to know how to apply both to every situation. The WFMLA may run concurrently with FMLA if both apply. Amount of leave. So standard FMLA situation, 12 during a 12-month period. Spouses working for the same employer, which is an issue that we see in school districts and in counties all the time, is that they share the 12 weeks if the leave for birth, adoption, or to care for a sick parent or child. WFMLA leave during a 12-month period, 6 weeks for birth or adoption, 2 weeks for serious health condition of a parent, child, or spouse, and 2 weeks for employees' own serious health conditions. Simplified steps. Sarah and I are going to go through these in more specific detail in subsequent slides, but in the broad strokes, number one, determine if the employee is eligible. 2, provide notice and eligibility of rights. 3, determine the type of leave and send the appropriate documentation form. Review the return documentation form, make your determination if the employee qualifies for leave, determine how much FMLA has been used by the employee previously and how much leave is now available, send the notice, keep everybody in the loop, and keep track of FMLA time used and obtain return to work form. Broad strokes, lots of information real quick, but in practical terms, if you walk away with one critical slide, here's your playbook checklist.
All right. So with that sort of as your intro to what FMLA is, let's talk more about the steps. So Dan and I are going to go through each step that was just on that prior slide, and we're going to break down for you a little bit what does each step look like in practical terms, so you actually know what you're supposed to be doing when you have one of these issues come to you. So step 1 is determine eligibility. So again, we have federal FMLA and we also have Wisconsin FMLA. They are by and large very similar laws, but there are significant differences. So you do need to know both, and you need to be very careful with determining eligibility for both. So the first step under federal or state is the question of, is the employer a covered employer? So luckily for you guys, counties are an automatic yes. Every county is considered a covered employer, so you don't need to worry about that. But just if you're curious, the general rule for eligibility is an employer has to have 50 or more employees. So typically that's what we're looking for, but for counties, again, you're not looking at that. So then the next question is the employee eligible for FMLA? So under Wisconsin law, what you're looking at, sorry, I'm skipping below to Wisconsin, but under Wisconsin, you're looking at, has the employee been employed by the county for at least 52 consecutive weeks? Meaning, have they been employed by the county for a year, a consecutive year period? I point this out because it does say consecutive. So that means if you have an employee who, let's say, worked for you for 3 months in a summer position, and then they took a break, they went and did something else for a while, and then they came back to the county, and now they've worked for you for 7 months. So if you put 3 and 7 together, that's 1 year. So perhaps they've worked for you for 52 weeks, but those are not 52 consecutive weeks. So in that scenario, that individual does not qualify for Wisconsin FMLA. The other caveat for Wisconsin is they must have been paid for at least 1,000 hours during those last 52 weeks. So that's what we look for Wisconsin. I'm going to point out that Beth just told me my math is wrong, and thank you, Beth. You are absolutely correct. I'm laughing because attorneys are notorious for going to law school because we're all bad at math. So I deeply apologize. You can all report back to Andy that I cannot do math. Maybe Dan is better. But you're right, 3 plus 7 is 10. That was a terrible example. Sorry, guys. But point being is you have to make sure it's actually 12 consecutive months, not 10. Okay, so federal FMLA, when we look at that, that's again 12 months. Have they worked for you for at least 12 months? And is it at least 1,250 hours during the last 12 months? And then I'll have Dan go to the next slide. And so step 2 in this process, let's say you've determined your employee is eligible. That means then you are going to need to send them the required notice of eligibility and rights. So this is a requirement. Anytime either someone has requested FMLA or you think they may need the FMLA information and you've determined that they are a qualified employee, then you're going to go ahead and send them that notice. You also generally are required to send them, or I'm sorry, to provide general written guidance to employees. You're going to do that through your policies, your handbooks, and you're also going to be posting a notice in a conspicuous place, such as an employee break room, locker room, kitchen, wherever employees are gathering. So we have the links on here to where you can find those required posters that you need to make sure are up. I'm sure you all have them up, but always a good time to check. And the other thing I would add here is that when we talk about policies and employee handbook language, FMLA is something that we don't see a lot of changes in year to year. So I feel like those policies often get short service when we are reviewing handbook language. But it's always a good idea to take a look and just confirm, does your policy say what you think it says? And does it contain all of that required information? So let this be a reminder, a good time maybe to dust off those policies, take a look, some light bedtime reading, because who doesn't love reading FMLA in the evening? Okay. This is also part of step 2. So I just spoke about the general notices, and this is, I've started to speak on this as well, that if you have an employee who's eligible, you have to give them the notice of eligibility. So that's the written notice outlining the specific obligations for the employee if they want to qualify for FMLA, or I should say request FMLA, as well as any consequences if they don't meet those requirements. So for federal, there's a nice handy template that has already been created for all of you. We've provided the link here of the notice that you would have to send to an individual employee who's requesting FMLA. That's from the U.S. Department of Labor. So that link is there. For Wisconsin, unfortunately, there is not such a handy template form available to you. I don't know why, but take that up with the DWD. So we don't have a link, but what I would say is you can also create your own notice form. And sometimes employers prefer that anyway, because sometimes people like to have one combined form for federal and Wisconsin. So that's what I'd say about that. And then on to step 3. So you've provided the notice to your employee. And now the question is, okay, what type of leave are they requesting or perhaps qualifying for? Let's figure that out and then determine the appropriate form to send the employee to fill out to actually document and hopefully get that request approved. So on the screen here, you're going to see the general types of leave that we have under FMLA. So we're going to break these down a little bit more specifically in a moment, but generally what we're looking at is we have birth of a child and bonding time with that newborn child, and that is for within 1 year of the birth if we're talking federal leave. We also can have FMLA for adoption or foster care, so placement of that child with the employee, as well as bonding time with that newly placed child. And then, of course, I would say birth of a child and employee's own serious health condition are typically the most common types of leave requests we typically see. But we do see all of these, I would say. But so an employee can get leave for their own serious health condition, as long as it's making them unable to perform their job functions. This can also include someone who is unable to perform their job functions due to pregnancy or related care or complications. That's something I do like to remind people of because usually people think of pregnancy and they think of birth of a child leave, but in fact, we often see those two coupled together. We see birth of a child, and then we also see the mother typically taking some leave for her own serious health condition, either immediately before or after the birth. Um, and then you also might have an employee who needs to take leave for the serious health condition of someone else in their life. So that could be their spouse, their child, or their parent. Um, we do see that. And then federally, we also see military service related FMLA requests, and we'll go into those in a minute as well. And then in Wisconsin, we also have for serious health condition, Wisconsin specifically allows for an employee to have leave to care for a domestic partner or parent-in-law. So as we'll point out throughout this presentation, you really do have to be careful with FMLA and Wisconsin FMLA when it comes to definitions. Terms and definitions vary a bit between these two laws, so we also need to make sure people qualify and which specific law they're qualifying under.
And with that, we're going to drill down a little bit on the types of leave, serious health conditions specifically. Many of the leaves under FMLA are dependent upon the employee or a family member of the employee having a serious health condition. That's why we belabor this point. Serious health condition is what you're often going to see. Employers need to be sure that the serious health condition, and we have some more slides on this, is being met in order to determine the correct course of action. We'll apply some definitions here, and if we get to it at the end, we have some examples too. Remember that Wisconsin and federal law have different definitions for a serious health condition. Serious health condition under the FMLA, an injury, illness, impairment, or physical or mental condition that involves either one, inpatient care, or two, continuing treatment by a healthcare provider for a condition that either prevents the employee from performing the functions of the employee's job or prevents that qualified family member from participating in school or other daily activities. 5 ways to qualify. This is a good slide to commit to memory. A period of incapacity of more than 3 days. Pregnancy, as Sarah mentioned before. A period of incapacity due to a chronic or serious condition, and a permanent period of incapacity. Absence to receive treatments as well. Serious health condition under the Wisconsin FMLA. A disabling physical or mental illness, injury, impairment, or condition involving inpatient care in a hospital, nursing home, or hospice, or outpatient care that requires continuing treatment or supervision by a healthcare provider. Leave would be for a serious health condition which makes the employee unable to perform his or her employment duties. A disabling serious health condition includes incapacitation or the inability to perform services for wages because of physical or mental impairment. And this is a note here, more than 3-day period of incapacity is not required like under the federal FMLA.
All right, so again, I already touched on this a bit, but for FMLA related to birth and adoption or foster care, we have some more specifics that we want you to just be aware of. So for birth and bonding leave under FMLA versus WFMLA, there is a slight difference, and it does matter when you're doing the math of the situation. So I've already shown that's not perhaps where I always excel, but I can promise you I do calculate FMLA correctly. So for FMLA, for birth and bonding, federally, you have to take that leave within the 12-month period, starting with the date of the birth, versus under Wisconsin law, it has to begin within 16 weeks of the child's birth. So something just to be aware of, it is up to the individual how they want to take that leave, but for you as the human resources person, or as the supervisor who might be monitoring this, you need to make sure that whatever the employee is requesting when it comes to the timing of this birth and bonding leave, you always want to double check, one, that they have the actual correct leave allotments still available, and two, double check that the timing of when they're taking the leave is correct and that it lines up with the date of the birth. And just note that, of course, this does apply. You can get birth and bonding leave regardless if you are male, female, it applies to everyone. Um, let's see here. And then, placement for adoption or foster care, same timelines that we're dealing with. So federal, you can get it, but it has to be within the 12 months of the date of placement. And for Wisconsin, it has to be within 16 weeks of the date of placement. Interestingly, we don't see this a ton, but you can use that Wisconsin and federal leave when it comes to adoption or foster care related to other parts of the adoption or foster care process. So that could be if you have to attend court hearings for the adoption, if you have to travel, if the adoption is taking place in another country. So just be aware of this. We would never want a leave to unintentionally get denied just because the person handling it wasn't aware of that caveat. Let's see here. I saw a question pop up, I think, about use of intermittent leave, and we are going to touch on that in just a few moments here. Okay, let's see. Type of leave, birth and adoption. Military leave. So I will say we don't, at least, I mean, I won't speak for Dan, but I will say I personally don't get a ton of questions on military leave when it comes to FMLA.
When I see it, it's usually in the school space, and it's pretty cut and dry. National Guard call-up deployment is what I'll often encounter.
Sure, and that makes sense. I think that's what we're commonly seeing. And so what I have actually up here for you, the first two are the actual FMLA leave types that someone could be taking that are related to military service. But the third item that I included is not FMLA, but I did want to include it. So that's USERRA. So that's the Uniformed Services Employment and Reemployment Rights Act. So I'll just touch on that first. It's not FMLA. It's not really a part of this presentation, but it comes up when we talk about military service and leave from work for military service. So USERRA is leave for the employee's own military service, like if they're deployed or at training. So it can come up for that reason. So just be aware of it. But specifically for FMLA, we're talking about either what's called qualifying exigency leave or military caregiver leave. So qualifying exigency would be something that relates to the fact that the employee's either spouse, parent, or child, that person is either on active duty currently or they're called to active duty. And if that happens, there are obviously issues that relate to that deployment. And so that would be something like maybe the employee has to make alternative childcare arrangements because the other spouse is currently deployed. Maybe they have to attend a military funeral, or perhaps spending time with that military member and caring for them while they're recuperating. So all of those could fall under this bucket. And then the other one, military caregiver leave, that is what it sounds like. It's caregiver leave. So it's if you have either a service member or a veteran, so it could be either, who has a serious injury or illness and the employee needs time off to care for them. So this is limited to the employee's spouse, child, or parent. It can also be their next of kin, which is defined as their nearest blood relative, which typically would be spouse, child, or parent, but just be aware of that caveat.
So, how do we find out what we have to do, right? Sarah was talking earlier about how sometimes these policies get short shrift in review because they're so long standing. They've existed for so long, we take them for granted. It's a poster, it's some handbook language, it's a policy. But in terms of the employee letting the employer know that this is coming, that time to plan can be invaluable. Under the federal FMLA, if leave is foreseeable, the employee needs to provide a 30-day notice. The employee must make an effort to schedule treatment so as not to unduly disrupt the employer's operations. For medical emergencies, it's as soon as practicable. Like, you get word on short notice sometimes for things like this. Sarah and I will get calls like that. What do we do with this? Sometimes there's not a lot of time to plan. Notice can be verbal or written. And under the Wisconsin FMLA, for scheduled appointments, the notice must be given in a reasonable and practicable manner. Again, must try not to duly disrupt the employer's operations. These notice requirements are things that you could belabor when you're doing your annual updates, sending out handbooks, highlighting policy changes, and that could serve to make your life a little bit easier in that employees might be aware of these requirements and more readily comply, thus giving you a little bit more time to plan. In terms of medical certification for a serious health condition, under the federal FMLA, you might require medical certification for the employee or the family member who's claiming the serious health condition. Employees must have at least 15 calendar days to return the medical certification. You can go to the DOL website to obtain these forms. This is like we referenced before. Under the Wisconsin FMLA, the suggested form has limited information that you can request. The same form is used for employees and family members. If a patient has a serious health condition, the date the condition began, probable duration, medical facts regarding serious health condition, but not diagnosis, extent to which the employee is unable to perform the duties. So you can go to the DWD and download a form there.
All right. Step 4. So once you have everything back, you need to obviously review it carefully, please, and determine, does your employee actually qualify for the leave they're requesting based on what they've turned into you. First point we always like to put out is consistency is key here. We say this because if you are inconsistent with how you apply FMLA, how you grant FMLA to your employees, that can lead to some serious legal risk and legal claims for your county. It could lead to a claim of interference regarding implementation of FMLA. It could lead to discrimination claims if you're, let's say, granting FMLA to the white 20-year-old employee, but you're denying it for a 55-year-old female employee of color. And it's for the exact same type of leave with the same type of documentation otherwise. So we just really want to be careful and give these leave requests the time they deserve. Doing that will really help you in the long run. Again, I think this also goes back to good policy development as well. I know we harp on policies a lot, but that's your guideposts as a county and as human resources. That's what you're using day in and day out to make sure that you are being consistent with employees. So both making sure the policies are up to date, as well as making sure that you're going back to those policies to help guide your process each time you're going through this. As Dan has said throughout, making sure you know the definitions and consistently applying those is also important. We know there's a lot of terms in FMLA, and sometimes those terms are the same and sometimes they're slightly different. So it's important to be sure you're drilling down each and every time to make sure someone in fact is appropriately qualifying. If it is an employee with attendance concerns, so I have up here that it can help enforce policies for employees with attendance concerns. And what I mean by that is, we've all been there. We have the circumstance where you have that problematic employee. I see Dan shaking his head. I know he's had these, it's the chronic attendance issue. Someone who's either always late, maybe they always suspiciously are calling in sick on Fridays and Mondays or before or after a holiday. We do see that certainly. And we're always suspicious of that. And often employers want to kind of jump right to discipline, like, well, can I fire this guy? He's never here on a Monday or a Friday. That's ridiculous. Oftentimes, what we're going to advise as an initial step is to first go through your checklist that Dan has flagged for you on these earlier slides, explore FMLA, and if that is something that this employee is appropriately qualifying for, you're also going to need to take a look at ADA and see if they're qualifying there. The reason we say that is to make sure you are making a legally sound decision if, in fact, we do end up going the discipline route. So if we've gone through the steps for each of these laws, for FMLA, for ADA, and determined that the employee does not qualify for FMLA, we've had that ADA discussion with the employee, which we'll talk about what that looks like in a minute, but we've had that discussion and determined they do not qualify for any type of accommodation. Then you're usually in the clear to proceed with disciplining that employee up to and including termination. But so that's why that is up here about attendance concerns.
I couldn't help but nod along when Sarah was speaking. In another
Yeah.
life, I was an organizational leader with approximately 1,000 employees.
Mhm.
And that frustrating moment when you're evaluating, just like when you're evaluating the problematic employees' documentation, right? Like we can relate here, but Sarah makes a good point that what you need to rely upon is good policy development, thorough documentation, and consistent treatment of everyone, regardless of how personally frustrating a problematic employee's choices might be to you. So we can relate. We hear this all the time, but policy development and consistency is absolutely key here.
Well, and honestly, Dan, I would say whether it's dealing with attendance concerns or just generally for FMLA claims or ADA claims, I think in all of these, it's really worth the time up front and maybe those few extra steps to make sure you're getting it right. Because the consequence on the back end, if you don't, could potentially drag you into months or years of continued back and forth with this employee with various claims, litigation, things like that if we don't get it right the first time. So I do think it's always worth the time to put in with that. So okay, let's see. Step 5. Okay, at this point, you also need to keep in mind how much FMLA has your employee already used, how much do they actually still have available. Um, and so part of what we look at when we figure out what does the employee have to use for FMLA leave, we have to look at what type of calendar you're looking. So again, I'm going to tell you, go back to your policies, because it can vary from county to county depending how your particular county has decided to draft their policies. So Wisconsin is easy. Wisconsin FMLA, WFMLA, it tells us it has to always be administered on a calendar year basis. So January 1 is the start of the calendar year. But when we look at federal FMLA, the employer actually has a little bit of discretion here. So you have to look in your policy to see how you are supposed to administer it. You can do it on a rolling year, you can do it a fiscal year, calendar year. Did you designate some other random 12-month period? You could have. Most people do either. Well, I shouldn't say that. We see rolling fiscal and calendar year. Those are the big ones, of course. Calendar year, I would say, or fiscal year. The negative to doing that is the employee can sort of maximize their leave time, because you might see them take 12 weeks of FMLA during the first calendar year. And then once January 1 hits, they get another 12 weeks. So that can lead to some issues. But the positive is if you're doing calendar year, it's much easier to administer because then you're synced up with WFMLA. Everyone's on the same cycle. It doesn't matter when the employee started their FMLA. They're not going to be on a different cycle than an employee in a different department. It really just makes it a lot easier on your team to administer if you're all on the same calendar for determining these leaves. So I do think that is certainly a positive. But the other option is if you wanted to do it on a rolling year basis. I mean, there's positives and negatives there too. I think perhaps other than the issue of administering it, I do think rolling year is maybe a little more employer friendly simply because you can't have employees doubling up. It just won't happen that way. Because on a rolling year, the year mark starts when that particular employee starts their FMLA. So that alleviates that concern. But again, the negative here is you have everyone on a different cycle. And so administering that, where not only is your federal FMLA using a different calendar than your Wisconsin FMLA, but also your employees are each on different one-year cycles, that can get a little tricky to administer. So I don't have a sense of if one method is more common than others for counties. But I'm always interested to hear what people are doing in that space. And I would just then note as well that when it comes to administering these, remember that Wisconsin and federal are going to run concurrently. So just be aware of that. And so just keeping in mind, you want to be really careful with your calendar dates. But yeah, then Dan, we can go to the next one. Sorry about that. Okay, substitution of paid leave. This is another big part of administering FMLA, is how you as an employer have decided that you want to handle the paid leave issue. So under federal FMLA, the county can require the employee to first use up any paid leave that they might have banked. So this is typically what employers want to do. So if you as a county want to be doing this, please go to your policies. Please make sure that it indicates this in writing in your policy. So if we're having employees substitute any paid leave, you can require them to first burn essentially all of their accrued leave. So sick leave, PTO, vacation, whatever the case may be, if you're requiring it. Because the consequence is if you don't require that, if you don't require them to substitute any paid leave they have, that can massively extend the amount of time your employee is out of work, which then puts the burden back on you as a county because you're left trying to, plug those holes of this person has been out for a really long time and how do we handle that? So, because if you don't require it, let's say you have a 15-year employee and they have a ton of vacation time banked because they just never take vacation. So suddenly they've taken their 12 weeks of FMLA. And then when their FMLA is winding down, they tell you that they also want to now take their, 18 weeks of vacation or however much you allow them to bank, but all of their vacation that they've banked over the years as well on top of it. So that can be really frustrating, of course, to employers. So we want to make sure your policy clearly says however you want leave substitution to work. Wisconsin FMLA is a little different. Under Wisconsin FMLA, you as the employer cannot require the use of paid leave, and the employee does get that choice to determine if they want to substitute their paid leave. A lot of times employees do because they don't want to be off without pay, but sometimes employees want to extend the amount of time generally that they can be off work. So then it's a benefit to them to take WFMLA unpaid and then still use their paid leave time after that. But in those situations, keep in mind, you probably have FMLA running concurrently. So just be careful with how those are stacking. And one more caveat here is just making sure for health insurance payments that you are tracking those because the employee, regardless of what's happening, if they are off on FMLA, they are required to still continue paying their share of those health insurance premiums. So always be tracking those. Intermittent leave. Okay, so we did have a question about this earlier. So intermittent leave, here is what you need to know. Intermittent leave, of course, is when you're taking leave for smaller chunks of time, versus continuous leave would be I'm taking all 12 weeks or all 8 weeks, however much I need all at once. Intermittent leave is the smallest block available in your payroll system. So however you as a county, whatever you consider to be your smallest block of time someone can take off, that's what it is. It can't be the employee coming to you and saying like, well, I only need to take 15 minutes or 10 minutes of FMLA today. So that's all I want deducted from my leave allotment. That's not how it works. It's dictated by whatever amount of leave you simply have in your payroll system. And then, so for FMLA, you need to, or yes, the employer is required to allow intermittent leave. And you can request additional documentation from the employee if for some reason you believe intermittent leave is not necessary. When it comes to birth, adoption, bonding leave, that's a little different. There, the employee has the discretion if you want to allow it, if you want to allow intermittent leave or not. So again, make the choice, be consistent with how you want to administer that. Obviously, be consistent with if you're approving or denying those requests, but also I would put it in your policy. That way it's upfront, employees know what the rule is, and also you know that it's being applied equally or consistently to everyone. Under Wisconsin, we do allow intermittent leave for all types of leave requests. So it's just federal here that treats it a little differently. And then there's also the caveat too that with intermittent leave, it's not necessarily carte blanche for the employee just to be off work at any time that they want necessarily. They are required to work with the employer, talk to their supervisor or HR to determine the best time for the intermittent leave to take place so that it doesn't unduly disrupt the employer's operations. So being aware of that. And then finally, when it comes to tracking what amount of leave the employee has used and what they have left, make sure supervisors know that they need to be tracking this carefully, or make sure the employee knows, if they're using some kind of time system or they're clocking in and out. But you want to be carefully keeping track of whatever time is used, because only the time taken off actually counts versus like the full block of time.
Sarah and I have seen some pretty elaborate tools for the tracking of FML in our time. So now we know what's going on, time to send a notice. So once you have enough information to know whether the requested leave qualifies, it's time to provide notice. Under federal, use the standard form, the WH 382, or you can create your own. Wisconsin's got a standard form, the DOA 15324, or you can create your own, or you can combine and use a summary of FMLA leave notices designated under both laws. So that's an option we've seen as well. Sarah alluded to this a moment ago, but there's a lot of different people within reason who you might want to keep in the loop here. For example, supervisors, secretaries, absence management folk, assistants within your own offices who track these sorts of things. You make a fact-specific determination regarding who needs which copies and when. And again, like we've said 3 or 4 times, consistency here is key. Creating a system that you can readily access and follow whenever you need to is also a benefit, net benefit to you, net benefit to the county, in that you do it the same every time, you develop a reliable system and you adhere closely to it. And tracking. We've talked about this a bit already too, but track used FMLA time and obtain the return to work form. Okay. Be sure to obtain a return to work form if needed due to medical leave from the employee. If an employee fails to return under certain circumstances, an employer may recover from employee its share of health plan premiums during unpaid FMLA time. Sarah and I have messed with this a couple of times. I'm sure some of you have as well. Gets a little sticky, but it is available to you under certain circumstances. You cannot do this when the individual is not returning because of a serious health condition or other circumstances out of the employee's control. If returns for 30 calendar days, considered to have returned to work. So if they're back within 30 calendar days, that's considered a return to work.
Okay, additional pointers, and actually this first point here touches on, I think, the most recent question I saw pop up in the chat about benefits. So there was a question about what if an employee is off on leave on FMLA and they're unpaid. They're not substituting whatever paid leave they've accrued. If that's happening, so they're unpaid, then can the county require that person to pay their full share of the premium versus just the employee portion? The answer is no. And that is because here, the continuation of benefits requirement under FMLA, if you're administering FMLA, you're required to continue the benefits just the same as you would if the person was working in that same position versus being off on leave. The employee does have to continue making their premium payments, but they're not making the full payment. And I think here, the way to think about this is really that, remember, at its core, FMLA is not a paid leave. It simply is a leave from work and job protection. It is not, the assumption, I would say, is not that the person is being paid while they're on FMLA, which is why that continuation of benefits is telling us, okay, if they're on FMLA, regardless of paid status, you do have to continue the benefit. So employer continues to pay that employer premium portion. The other, again, core value, I would say, of FMLA is that right to return, or we also call it reinstatement rights. And that is that if the employee is on FMLA, you are required to hold their position. They have to be restored to the same or equivalent position. I say equivalent position, but I'll be honest, we typically consider it pretty much the same position, because if you want to find an equivalent position to put the person in when they return from leave, it literally has to be a position that has all terms and conditions of employment that are the same as the position they were in when they went out on leave. So there is the possibility you may have a situation where you're going to do an equivalent position instead of the same position. That certainly happens, but you just want to be careful there because it really does have to be an exactly equivalent position, I would say, or pretty close. So I would say that's an area where if you're not returning the person to the same position, I would consider consulting with legal counsel just to double check that you're doing that appropriately. And then finally, just record keeping. Remember that any medical records, which you will of course have for an FMLA request, remember that medical records and anything related to that needs to be kept in a separate file, and making sure those files are secure. And then legal challenges, we do see occasionally interference claims. So these are the elements you would look for in an interference claim. I'm not going to read them to you, but just be aware that that's what we look at if such a claim is brought. And so if you ever, of course, have an interference claim, you're going to want to involve your corp counsel and your legal counsel right away, so that we can assist with that.
And now ADA, right? We've made it to the ADA. Basics. The Federal Americans with Disabilities Act and the parallel state law, the Wisconsin Fair Employment Act, are a set of laws that prohibit unlawful discrimination against a qualified individual on the basis of disability in the employment context. ADA in a nutshell. So a failure to provide reasonable accommodations, which might include leaves of absence, is a violation. So a lot of what we just discussed becomes relevant and intersects here in the ADA. So what's a qualified individual? They must have the requisite skill, experience, and education to perform the essential job functions with or without reasonable accommodations. So that gets you to the starting line. An essential function is essentially the job duties, evidence of which can be shown basically with the employer's judgment, pre-interview job descriptions, and time spent actually performing the function. And you're eligible on day one. So unlike FMLA, we have a different, much shorter timeline here.
So I will just note before I keep going here that, of course, Dan and I talk too much because we're lawyers, so we're a little short on time, but I want to make sure we get through the ADA information with you. But I want to point out that the reason we pair these topics together is because, yes, someone can qualify for the ADA on day one of their employment with you, as Dan just said. So that's different from FMLA, where they have to have worked for you for the past year. So yes, they could qualify on day one. But the reason these two laws intersect is we often have situations where someone is off on FMLA, but then they've used up all of their FMLA and they still need leave or claim that they need leave for some reason. And so that's where the ADA can kick in, and it often does. And so that's why this process needs to, in your mind, be linked together with FMLA. So under the ADA, you have to look at, does this person have a qualifying disability? So the ADA does have a specific definition. So we have it up here, but essentially, do they have a physical or mental impairment that in some way substantially limits or restricts their one or more major life activities? So I have examples up there, but what you would think of: walking, standing, sitting, breathing, hearing, and anything that is considered a major life activity. If they have an impairment that restricts those, then they may qualify as having a disability under the ADA. So again, it's another law where you want to be carefully applying the definitions. There's two caveats at the bottom under the definition of disability. So one, does this person have a record or a history of impairment? So that's important to look at too when you're determining if they are qualifying as having a disability under the ADA, or have they been misclassified as having it? And when I say that, this is why you want to be careful the first time around when you determine if an employee has a disability, because if you misclassify someone and determine, yes, they have a disability, and then treat them as such, if you decide later down the line that actually what they have does not qualify as a disability, that can be very difficult to walk back. So that's why you want to be really careful here with these definitions. Similarly, another way you can be determined to have a disability under the ADA is if you're regarded as having such an impairment. So that could look like an employer who thinks an employee has some type of disability and they treat them as such, or maybe provide some type of accommodation without actually going through the interactive process. So maybe the person actually doesn't have a qualifying disability, but the employer never bothered to find out because they didn't actually go through the steps. So just being careful with that. And then on the next slide, this is the information you need to know about, okay, well, when does my duty to accommodate them under the ADA, when does that happen? So you have that qualified individual with a disability, and then do you as the employer have knowledge of the disability? So that's key. And I think that's perhaps the thing I want you to highlight on this slide. So it doesn't have to be a formal request. This doesn't have to be magic words, doesn't have to be the employee saying, hey, I think I have a disability and I think I qualify for an accommodation under the ADA. They don't have to say any of that. It could really be you notice an employee has an attendance concern. And so then your first step is to go maybe talk to them and say, hey, I noticed you really are struggling to be present at work. Is there, something we need to talk about with that? Do you need assistance? Is there anything you think we as the county can do? So being aware that that can trigger it. Or let's say a supervisor notices that an employee keeps falling asleep on the job. Sometimes that's enough for us to say, yes, you as the employer, you had knowledge. So you just want to be aware of that. And also, I think that really ties into making sure your supervisory staff is properly trained to just enough to recognize when the ADA might come into play so that they know when they need to contact HR. Let's see here. And so as I said, the warning slide, this is because being aware of when the interactive process can be triggered, either because you've generally noticed a problem, noticed an issue that could be a disability, or it could be triggered because FMLA has run out and that person still has whatever health condition that could be a disability. And so that's going to trigger the interactive process.
And just to drill down a little bit further on the interactive process, the goal is to gather information through dialogue, which you would document. You're required by the ADA under good faith obligation to be collaborative. Like, this is not one-sided decision making. This is a partnership. And the typical process documented throughout typically involves medical documentation, identifying those essential job functions, dialogue with the employee about limitations, potential accommodations, workshopping potential accommodations, exploring reasonable options that enable performance. We put some common examples in there, like a modified schedule, reassignment, specialized equipment, or forms of leave. And then an assessment regarding undue hardship, costs, resources, disruptions. What can you reasonably anticipate? And then we would implement and monitor the chosen accommodation and adjust accordingly, perhaps set an interval for some internal goalposts and check it. A little bit further down the line here, any change or adjustment to the job or the work environment or the ways things usually are done that would allow for the job performance functions, or enjoy equal access to the benefits and or privileges available to other individuals in the workplace. An unpaid leave of absence is one such reasonable accommodation. We put this in there specifically because we'll see this request come often. This is true even if FMLA leave has been exhausted. So Sarah alluded to this a little bit earlier. This is that intersectionality slide. We might have gone through FMLA situations in the past, and here we are in an ADA situation. It's important to remember, just because FMLA leave is exhausted doesn't mean we don't find ourselves offering unpaid leave of absence as a reasonable accommodation. Terminating an employee automatically at FMLA or WFMLA exhaustion without considering AD obligations may violate the ADA. So this is, again, intersection bullet point. And finally here, leaves as an accommodation. Leave may be a reasonable accommodation unless the leave will cause an undue hardship. I think it was 3 slides ago, we talked about calculating costs, and that's in preparation for this. That's that undue hardship on the employer calculation. Any action that is too costly, substantial, or disruptive, or that fundamentally alters the nature of the employee's business might qualify as an undue hardship. Engage in the interactive process with the individual to determine whether leave is a reasonable accommodation, get as much information as appropriate, including medical documentation, and information about how often or how long that leave will occur. And remember, there is no limit on the amount of leave that may be taken. Leave typically may not be for an indefinite period of time, though. We have a note too. There's some conflict between decisions in the 7th Circuit and Wisconsin under the law.
So just to jump in and kind of add, or maybe add an emphasis to something in these slides Dan just went over. I know we're running up on time and I want to respect everyone's time today. But yes, I saw the note, the question about, yes, we will be posting, or I should say Sarah will be posting our slides as well as the recording today to the website. So you'll have access to them afterwards. But what I was going to say is when it comes to determining reasonable accommodations and determining if the employer has an undue hardship, that is not something that is dictated by the employee's doctor. I get questions about that sometimes because the employee might come to you with a doctor note that says, oh, so-and-so needs to have a therapy dog with them at all times at work, or they need to, I'm trying to think of what crazy ones I've seen. If the employee comes to you and says, hey, my doctor says I need X, give me X, it doesn't necessarily mean that X is in fact the reasonable accommodation that you as the employer are required to give. You as the employer still have to go through your own analysis, and you are able to come up with what the reasonable accommodation is that you believe you can in fact offer. And you get to determine if something is in fact an undue hardship. So sometimes it is the same. Sometimes whatever the physician or medical professional recommends or advises is in fact the accommodation that we're going to give, but they're not always the same. So just be aware of that whenever you are dealing with these requests. And then real quick in the last 3 minutes we have here. We've talked about this a little bit kind of as we've gone, but being aware that these 2 laws, FMLA and ADA, they interact with each other. So being aware of that, being aware you might have to deal with both laws for a particular employee, but also knowing that that won't always be the case. Not all employees will qualify for FMLA and the ADA. There's different definitions that we have at play. Some employees, like let's say you have an employee who's only worked for you for 2 months, they're brand new, they're not going to qualify for FMLA, but they might have a disability that qualifies them for accommodations under the ADA, which could include at-work accommodations, but it could include some amount of leave as well under the ADA. As Dan said, though, some amount of leave is typically considered a reasonable accommodation under the ADA, but not indefinite leave. So always being careful when you have leave requests under the ADA, and just knowing that typically what we see is often a shorter and defined period of leave under the ADA is considered reasonable, but it's when you get into those longer or continuing periods of leave with no end date defined by the medical provider, that's often when we are able to deem a request to be not reasonable under the ADA. So just being aware of the interplay between those laws.
And here, nearing our conclusion of time, HR's role in managing the interplay. We've talked about this already. Monitoring the leave periods, tracking concurrent FMLA and WFMLA leave in anticipation, engaging in that process, the dialogue before the end of FMLA. If the employee indicates continuing medical issues, clear communication, and some common mistakes to avoid. Automatic termination after FMLA leave, failure to consider a leave of absence, intermittent leave, or reduced schedule accommodations, ignoring the ADA if the employee is not yet FMLA eligible, which Sarah alluded to a few moments ago, and not continuously reviewing job descriptions. This happens. Like we get complacent, we don't revisit those job descriptions, and calendaring that as an annual process is really a best practice. And finally, failing to consult with legal counsel for complicated cases as early as problems begin to set off your spider senses.
Yeah, and Dan, I think, and I know we're at time here, but I do think that review and updating of job descriptions on hopefully an annual basis, that's a big one. I know I can't tell you the number of times I've asked an employer if they even have a job description generally for a particular role, much less has it been updated since the 80s. The number of times that the answer is no, we don't have that is surprising. So in addition to reviewing your policies, go back and take a look at job descriptions. And then just on the last slide for helpful tips, these are really things that we've been talking about throughout this whole presentation. So again, being consistent with how you're administering these laws, that only helps protect you as an employer from legal risk, making sure you're updating all of your policies, and training your staff, training supervisors, anyone who might be in a supervisory role to an employee and is that go-between with HR. They need to know when something needs to trigger them to go speak with HR and maybe talk about next steps. So take a look at that helpful tips slide, make sure you're implementing everything there. We do have a couple scenarios at the end that I think we're out of time for, but I think they're all pretty apparent if you want to take a look at them, if you have questions on them. Dan and I have our contact info on the very last slide. Feel free to reach out. But thank you all. If there's anything else, you know where to find us, or feel free to bug Andy Phillips about any of this information, and he's happy to help as well.
I'll leave you with one parting sentiment. People underestimate what they can accomplish in a year. They overestimate what they can accomplish in a couple of weeks. Job descriptions and policy updates. If you set a post-it on your wall analog and say, I'm going to do this in 2026, you'd be surprised at what you can accomplish if you break it into chunks and the dividends that will pay later on.
Yeah.
Dan and Sarah, thank you. Do you guys have a couple minutes to answer some of the questions that came in under the Q&A?
Sure. Yeah, I didn't realize we'd missed some.
Yeah, I think we missed some because there's the chat and the Q&A. So I don't know if you had both of them.
Oh, I only see the chat, I think.
Yeah. So the Q&A, there's a Q&A as well.
Yes, I see that. We did miss quite a few.
Okay. So I didn't know if you had a couple minutes just to run through some of these very quickly. So
Sure.
catch them. If they need to leave, they can catch them on the recording.
Okay, let me see here. So the first one,
I think we could start with the questions at starting at 12 p.m. in the Q&A.
okay.
Starts if an employee was taking unpaid leave not under FMLA, just accommodation, would this time count for federal FMLA eligibility?
Oh, okay. So no, the answer is no. So if someone is taking a general unpaid leave, um, that doesn't count against FMLA eligibility in the time of the amount of time under FMLA someone has left. So this could be, as an example, some employers simply have a general unpaid leave policy in their handbook that just allows someone to take a general unpaid leave. That doesn't count against FMLA. Or if someone qualifies for the ADA and is taking leave under the ADA, that also does not count against FMLA eligibility. The only way your FMLA eligibility is ticking, or not eligibility, the only way your FMLA leave allotment is ticking down is if the person has actually gone through the process, they've gotten the paperwork, they've turned it back into you, and you've in fact approved their FMLA. Let's see. And then the next question I see on here is about the eligibility notice. And the question is, what if they have intermittent leave? Can you do, I think, the eligibility notice just once? If they have intermittent leave, what if they have an FMLA need later for a different health issue? Do you send another eligibility notice? So the way it works with FMLA is you are going to be approving their FMLA for a particular health issue or a particular type of FMLA. Remember when we went through that list of, I think it's 6 or so. So their own serious health or condition, birth or adoption of a child, those are all different types. So if you give them the eligibility notice and approve them for, let's say, birth and adoption of a child, that's one instance. But then later on, let's say they have a different issue arise, their own serious health condition, you would want to give them that eligibility notice again and go through the process again with them. Let's see. For eligibility, is there a difference between hours worked versus hours paid? Difference between hours worked versus hours paid. So I'm trying to think of what a good example would be of this. Let me come back to that one. Okay, then the next one is, should we request certification for an employee requesting FMLA to take care of a veteran? I would say it depends. I don't know if you've had this situation arise, Dan, and I don't know if you can see these questions since I know you're in presenter mode. Okay. This, I think, is something where, I don't know, let's say both spouses work for the county. And if you know this person is, in fact, is currently recovering from surgery, I don't know. I could see maybe there being a situation where you don't need that medical certification, but by and large, I would say yes, you still need to get it.
As a general rule, I agree.
Yeah. I'm trying to think if there's ever a situation, but generally we always say to get that certification. If there's ever a reason you don't think you need it, I would check with your corp counsel or legal counsel. Let's see. Can an employee continue to use FMLA year after year for the same condition? Every year take off 12 weeks for the same issue. So no, they can't just continue it year after year because, well, and this actually kind of goes to the prior question that I skipped over. The reason they can't continue to do it is because they're not in paid status. If let's say they're out of paid leave to substitute, so they're taking 12 weeks of unpaid leave. If that's the case, they're not going to qualify the next year. So at some point, they will run out of eligibility. Let's see. What is the best practice for designation or notice, i.e., an employee is taken off work for 5 days by a provider for an illness. Leave can be designated after 3 days off for the medical condition. I designate after the 3 days, even if the employee did not request FMLA. So I don't know that you need to be automatically designating it, but once an employee is off for 3 days in a row, that should trigger you to start that FMLA process and send the paperwork. Because that way, if the employee does have a condition that they believe qualifies for FMLA, that will start that process rolling. And Dan, feel free to jump in if you have additional
I agree.
practical tidbits that you've seen. Otherwise, I'll just keep reading here.
Keep going.
Let's see. On FMLA, we require employees to use their accrued time, but we allow them to spread it out if they don't have enough to cover the whole time they're off. Okay, so you let employees use their accrued vacation, PTO, but they're not required to use it all in one continuous chunk. And I'm not sure what this says. It's cover the benefit premiums. I feel like there's a typo in there, and I'm not sure what that's meaning, but do I see any issues with this? So my concern would be, are we treating all employees the same with this? That's the concern that comes to mind for me. If you're allowing perhaps one employee to spread out their paid leave however they want to take it versus maybe another employee is not allowed to do it exactly how they're requesting it. That would be a concern I might have with that.
This might be one to drill down a little bit further on. I see what you're trying to accomplish here, but we might need a closer look.
Yeah, it's an interesting question. I'm still thinking about it because I don't know if I've had an employer ask specifically this before.
My gut tells me that the insurance premium portion is they're paying their insurance share.
Yeah.
But they're using that money to pay it on an incremental spaced out basis.
Yeah.
So they come up with the cost at the point of service.
Which I understand. And I do really appreciate when employers want to create policies that are employee friendly and benefit their employees. I absolutely appreciate that. I think my concern is just making sure, are we doing this consistently for all employees, however it's being administered? Because you certainly, again, can let someone substitute whatever paid leave balance they have. It's just a question of what does it actually look like? How are you doing it? And what does your policy say? I would go back to that. And whatever you're currently doing in practice, is that actually what's written in your policy? And if not, if they're a little different, let's make sure we're changing it so that they align and so it's clear how it's being administered.
And I was going to say too, just in the chat, a clarification came in on them. They say it helps them cover their benefits to spread it out.
Yeah.
All employees are treated the same.
Okay.
Then also another said as an example, Susie has a baby and she's off for 6 weeks, but only has 4 weeks of time. She requests to break the number of hours we are paying to push for coverage through that 6 weeks so they don't owe premiums when they return. So.
And exactly what Dan was guessing that the reason was. Yeah. And I understand and appreciate that. And I would say generally, I don't see any issues with that as long as you truly are treating all employees the same with regard to that. The thing that flagged in my head is just, is there ever a situation where an employee asks for a certain schedule that they want their paid versus unpaid time to be used? And is there ever a situation where the county would deny? That would be, I think, my only concern.
Good question.
Yeah, no, a really good question. Okay, where did I leave off here? Oh, okay. Does the disability, so we're talking, okay, does the disability have to be permanent or can it be situational, such as being unable to bend or stand due to a high-risk pregnancy? That's a great question because we do see that both with pregnancy-related issues and just other health concerns. It doesn't have to be permanent to be qualify as a disability. Go back to the definition slides we had, and also the definition, of course, is a little more complete if you actually look at the ADA, but there is a very specific definition, and both can be covered under the ADA. Let's see here. What if a job description has physical duties required upon hire, and then a new disability keeps the employee from performing those duties? So if someone's job description requires certain physical duties and the person knows that when they're hired, and then a disability arises where they can no longer perform some of their job duties, that is actually when the ADA is going to be triggered. That's a great example. So it is possible you may have to provide some sort of accommodation, but it's also possible that maybe no reasonable accommodation exists. So this is one of those classic lawyer, it depends situations on really what the facts are. But just know that the ADA would be triggered by that. So you would at least have to start going through that interactive process and see where you end up. And if that's something that's happening right now, I would say it's a great time to reach out to legal counsel and see if you can kind of talk through what the status looks like for that. And then last one on here, I read that spouses who work for the same employer share a total of 12 weeks of FMLA per year for birth of a child, placement of child, and to care for a parent with serious condition. Yep. How is it possible the parent situation, knowing that under federal FMLA doesn't recognize parent-in-law as a family member? That is a good observation. We do have some differing definitions here. So one, correct, that if you have two spouses working for the same employer, as we talked about earlier, there are certain types of leave where those two spouses are going to share that same 12-week leave bank. So the question is, if the leave is for caring for a parent for a serious condition, how does that work if a parent-in-law is not recognized as a family member? So you would be going by definition. So if whichever law we're under, and I don't have it up in front of me, if the law only allows you leave to care for your parent and not your parent-in-law, then you're not sharing the same batch of leave. If that makes sense, like you would have the leave to care for your parent, but not your parent-in-law. Versus if you're under, let's say, I think it's WFMLA that does recognize it, then you might be sharing that same leave bank.
All right. I think that takes care of the questions about the chat and the Q&A. Dan and Sarah, thank you so much. I think this was an absolutely wonderful webinar. Lots of information. Again, everything will be posted on our website, both the PowerPoint presentation as well as the recording. And just as to wrap it up, a reminder to everybody that we will be back with our next segment of In the Boardroom on May 27th, where the topic will be roles and responsibilities of constitutional officers and department heads in the Wisconsin County government structure. So again, Sarah, Dan, thank you for joining us this time. We'll all report back to Andy what a wonderful job you did. Thank you for joining everyone else, and have a great rest of your day.
All right. Thanks, everyone.
Thanks, everybody.
Bye.